The sun had barely risen over the palm trees of Homestead when the unmarked vehicles rolled down the quiet residential street. It was a Tuesday morning in late January, the kind of morning when kids were supposed to be getting ready for school and parents were supposed to be drinking their coffee before work. But this morning was different. This morning, federal agents wearing tactical vests emblazoned with the letters ICE were knocking on doors, checking identification, and within hours, an entire neighborhood would be transformed. This scene playing out in South Florida is not an isolated incident anymore. It is the new normal under a sweeping set of deportation laws that have made Florida the most aggressive immigration enforcement state in the entire country. And the people being affected by these laws are not just who you might think. Governor Ron DeSantis stood at a podium in Sanderson, Florida on January 5th of this year, flanked by law enforcement officials from more than a dozen agencies. Behind him, a banner proclaimed the success of Operation Tidal Wave, the state's flagship immigration enforcement initiative launched just 8 months earlier in April of 2025. The numbers he announced that day were staggering. Over 10,400 arrests of undocumented immigrants across the state, 3,400 from Guatemala, 3,300 from Mexico, 1,400 from Honduras, hundreds more from El Salvador, Venezuela, and countries spanning Central America, South America, and beyond. These were not just statistics to the governor. These were proof that Florida's approach was working. But to understand how we got here, you have to go back to May of 2023, when DeSantis signed Senate Bill 1718 into law. That legislation was considered radical at the time. It required hospitals to ask patients about their immigration status. It mandated E-Verify for employers with 25 or more workers. It made it a third-degree felony to transport or harbor undocumented immigrants into the state. Critics called it cruel, supporters called it necessary. But either way, it was just the beginning. The special legislative session of February 2025 changed everything. In a matter of days, Florida lawmakers passed 2 bills that would fundamentally reshape the landscape of immigration enforcement in the state. Senate Bill 2C created the State Board of Immigration Enforcement, a cabinet-level agency with unprecedented power to coordinate between state and federal authorities. It ended in-state tuition for undocumented students at public colleges. It allocated nearly $300 million specifically for immigration-related law enforcement activities. But it was Senate Bill 4C that made national headlines. Under Senate Bill 4C, any adult who enters Florida without legal immigration status commits a first-degree misdemeanor punishable by up to 1 year in jail. A second offense becomes a third-degree felony with up to 5 years in prison. And here is where the law takes its most dramatic turn. If an undocumented immigrant is convicted of a capital felony, such as first-degree murder, the death penalty is not just possible, it is mandatory. There is no judicial discretion. There is no consideration of circumstances. The sentence is automatic. Legal scholars immediately challenged the constitutionality of this provision. The ACLU filed suit within weeks. Federal courts issued preliminary injunctions. But the intent was clear. Florida wanted to send a message that would echo far beyond its borders. And now, in 2026, the state legislature is pushing even further. House Bill 197 will require every single private employer in Florida, regardless of size, to use the E-Verify system to confirm the work eligibility of every new hire. Currently, only businesses with 25 or more employees must comply. Starting July 1st of this year, even a family-owned restaurant with 3 employees or a landscaping company with a handful of workers will face penalties for failing to verify immigration status. The consequences for violations include suspension of business licenses, making this one of the strictest employment verification laws in the nation. But employment is just one piece of a much larger puzzle. Chief Financial Officer Blaise Ingoglia announced legislation in January that would fundamentally change how undocumented workers are treated when they get injured on the job. Under current Florida law, workers' compensation covers employees regardless of their immigration status. If you get hurt at work, you are entitled to medical treatment and lost wages. Ingoglia's proposal would strip that protection entirely from undocumented workers. They would receive nothing. No coverage, no benefits, no support. And here is the twist. Employers who knowingly hire undocumented workers would become personally responsible for all injury-related costs out of their own pockets. The stated goal is to discourage hiring undocumented labor. The practical effect would leave injured workers with nowhere to turn. The same legislation targets car insurance. Currently, when there is an automobile accident in Florida, fault is determined by the circumstances of the crash. Under the proposed rules, if one of the drivers is an undocumented immigrant, that driver is automatically at fault, regardless of what actually happened. It does not matter if the other driver ran a red light. It does not matter if the other driver was texting. If you cannot prove legal immigration status, you bear full responsibility for the accident. The financial restrictions extend even further. One bill advancing through the legislature would prohibit state-chartered banks and credit unions from opening accounts for anyone who cannot prove lawful immigration status. Down payment assistance programs, which help first-time homebuyers purchase property, would become off-limits. The message embedded in every one of these proposals is unmistakable. Florida does not want undocumented immigrants to work here, drive here, bank here, or build any kind of life here. Senator Don Gates introduced Senate Bill 86 after a fatal crash on the Florida Turnpike in August of 2025. 3 people died when a commercial truck crossed the median. The driver, Harjinder Singh, was later identified as an undocumented immigrant. Under Gates's bill, any unauthorized immigrant found operating a commercial vehicle can be immediately detained and transferred to federal custody. The legislation came alongside a federal crackdown that shut down nearly 3,000 truck driver training providers across the country for fraudulently certifying drivers. Transportation Secretary Sean Duffy praised the coordination between state and federal efforts. But the enforcement infrastructure that makes all of this possible has been building for years. Every single county jail in Florida has now signed a written agreement under Section 287G of the Immigration and Nationality Act. These agreements allow local law enforcement officers to perform certain functions that were traditionally reserved for federal immigration agents. When someone is booked into a county jail, their fingerprints are automatically checked against Immigration and Customs Enforcement databases. If there is a match, ICE is notified. If ICE wants to take custody, the local jail holds the person until federal agents arrive. Since January 20th of 2025, the number of these agreements in Florida has increased by 577%. The state now has 325 active agreements, more than any other state in the country. The detention facilities housing all of these immigrants have become their own controversy. Deep in the Everglades, at the Dade Collier Training and Transition Airport inside Big Cypress National Preserve, sits the South Florida Detention Facility. It earned its nickname almost immediately, Alligator Alcatraz. The remote location, accessible only by a single road through swampland, makes visits from family members or attorneys extraordinarily difficult. Guards reportedly nicknamed it for the wildlife surrounding the facility. The conditions inside have drawn international criticism. When Alligator Alcatraz reached capacity, the state opened a second facility. The former Baker Correctional Institution in Sanderson became Deportation Depot in September of 2025. It can hold up to 2,000 detainees. The cost to equip the facility was approximately $6 million, which officials described as a fraction of the overall $330 million immigration enforcement budget. Unlike federal immigration detention centers, neither Alligator Alcatraz nor Deportation Depot appears in the ICE online detainee locator system. Families searching for loved ones often have no idea where they are being held. Governor DeSantis is currently seeking federal approval for a third detention facility. The state has spent at least $573 million on immigration enforcement since launching these initiatives. FEMA approved over $600 million in emergency funds after DeSantis declared an immigration emergency, an executive order he has renewed 19 times, most recently in December. Democratic legislators have attempted to end the emergency declaration through a concurrent resolution, arguing that border crossing numbers are at their lowest point in years. Their efforts have gone nowhere. The human toll of these policies extends far beyond those who are undocumented. Consider the mixed status family, a household where some members are citizens or legal residents and others are not. There are hundreds of thousands of these families in Florida. Children who were born here, who are American citizens by birthright, who have never known any home other than this state, are watching their parents live in fear every single day. School enrollment among immigrant communities dropped by more than 46,000 students this year. Parents are afraid to drop their children off at school. They are afraid to go to the grocery store. They are afraid to seek medical attention when they are sick. The psychological impact on children in these families has been documented by researchers across multiple institutions: anxiety disorders, depression, trauma responses. Children are developing symptoms that mirror those seen in young people who have experienced war or natural disasters. They are preparing for the possibility that when they come home from school, one or both of their parents might simply be gone. But here is what might surprise you most about Florida's new deportation laws. They are also affecting people who are legally present in the United States. Green card holders, DACA recipients, those with temporary protected status, all of them are discovering that Florida's aggressive enforcement environment creates new vulnerabilities they never anticipated. Under federal immigration law, lawful permanent residents can be deported if they are convicted of certain crimes. The list of deportable offenses is long and includes many things that most people would consider relatively minor. Florida law defines felonies more broadly than many other states. Shoplifting merchandise worth more than $750 is a felony. A DUI that causes any physical injury is a felony. Possession of certain quantities of controlled substances is a felony. Green card holders who have lived in this country for decades, who have raised families here, who have built businesses and paid taxes and contributed to their communities, are discovering that a single mistake can trigger removal proceedings. DACA recipients face their own unique challenges. While the Deferred Action for Childhood Arrivals program has provided protection for immigrants who were brought to this country as children, that protection is not permanent. It must be renewed. And recent policy changes have put renewal applicants at increased risk. DACA recipients with any criminal record, even minor offenses, are facing heightened scrutiny. Some have been detained. Some have been placed in removal proceedings. The uncertainty is constant. The economic consequences of these policies are becoming impossible to ignore. A Wall Street Journal analysis found that non-citizens comprise approximately 1/3 of Florida's construction workforce and nearly half of its agricultural workers. The citrus industry, the tomato fields, the strawberry farms, all of them depend on immigrant labor. When workers stop showing up because they are afraid of being detained, crops go unharvested, projects go unfinished, costs go up. A survey of landlords found that 67% reported negative impacts from immigration enforcement policies. In some areas, vacancy rates have jumped from 2% to 30%. Property owners who invested in rental housing are watching their buildings sit empty. Meanwhile, the Department of Housing and Urban Development has given landlords 30 days to verify citizenship for approximately 200,000 tenants receiving federal rental assistance. Families are being forced to prove their legal status or face eviction. The construction industry is bracing for what one analyst called a shoe about to drop. ICE raids at job sites have increased dramatically. A single raid at a Georgia Hyundai plant detained 475 workers. Contractors are struggling to find qualified labor at any price. Data center projects, which can pay premium wages, are outbidding residential and commercial developers for the limited workers available. The One Big Beautiful Bill Act, passed by Congress, included substantial new funding for ICE operations, suggesting that enforcement will only intensify in the months ahead. In March of 2025, Florida launched a public tip line through its Law Enforcement Accountability Dashboard. The stated purpose was to allow citizens to report law enforcement agencies that were not cooperating with immigration enforcement. But the actual reports that came in tell a different story. People reported their neighbors. They reported their son's bus driver. They reported the family down the street who they suspected of being undocumented because they heard music they did not recognize. The tip line received complaints about loud parties, about personal disputes, about grievances that had nothing to do with immigration at all. Historian Fraser Ottinelli warned that the tip line creates a climate of suspicion that corrodes community trust. Resident Catherine Cominio compared it to tactics used in Nazi Germany, a characterization that immigration authorities rejected, but that reflects the depth of fear in affected communities. A separate portal called the Combat Violent Extremism System has accumulated over 6,400 pages of responses. Obtaining records about what is in those reports through public records requests cost one news outlet over $7,000. What happens next is uncertain. Federal courts have blocked portions of these laws. Legal challenges are working their way through the system. But the intent is clear and the impact is already being felt. Florida has positioned itself as the national leader in aggressive immigration enforcement. Governor DeSantis has called it the gold standard. Other states are watching. Some are considering similar measures. For the millions of people living in Florida who are affected by these policies, the question is not abstract. It is immediate. It is personal. It is about whether they can go to work tomorrow without fear, whether they can take their children to school, whether they can stay in the only home many of them have ever known. The laws on the books in Florida in 2026 represent a fundamental shift in how this state treats immigrants, and in many cases, how it treats anyone who might look or sound like they could be an immigrant. The enforcement infrastructure is in place. The detention facilities are operating. The tip lines are active. The message has been sent. And the people receiving that message include not just those who crossed a border without authorization, but business owners and landlords and employers and neighbors and children who are American citizens wondering what will happen to their families. That is the reality of Florida's new deportation laws. That is who is affected, and that is the story that is only beginning to unfold.